We can invite the people. I think the 7 now. Yeah,
Okay, perfect.
7. Yeah.
Dina, should I start? Ready?
Okay.
We can
Okay,
invite the people.
perfect. Good evening and welcome to today's session, the bylaws of the new Egyptian NGOs law. This is Kareman Shoair. I run the research unit of the Gerhart Center. For those of you who are not familiar with our work, we are a center hosted in the School of Business. They consider us to be the social arm of the business school, as we mainly focus on issues related to social and economic development. Please make sure to check our website and social medias to learn more about our research and youth leadership programs. This session is a part of the GC Social Talk series, one of the Gerhart Center's main platforms that aims to initiate open dialogues around different issues arising in the development space, either locally, regionally, or internationally. Normally, we undertake the GC social talks physically on campus, but given the current situation, we are meeting in a virtual platform. Today's discussion is a very important and timely issue, especially for those who work or interested in civil society and the non-profit space at large. After a long wait, now we have the executive bylaws of the NGOs laws, and luckily we managed to get the very right expert to lead a discussion around this issue, Dr. Issam Adawi. Dr. Issam, thank you so much for fitting us in your very busy schedule. We really appreciate it.
Happy to do that.
Thank you. Before I pass the floor over to Dr. Issam, let me first introduce him. Dr. Issam Adawi is a seasoned social and economic development senior practitioner with over than 35 years experience working in development and in developing and industrialized countries in conceptualizing, planning, implementing, and evaluating programs in social development fields for various regional and international organizations. Dr. Adawi has a degree in social development from St. Francis Xavier University in Canada and a master's degree in social science from the University of West London. Of course, in addition to his medical degree from Asyut University in Egypt. Dr. Adawi has served as the Ministers of Social Solidarity Senior Advisor for Social Society and International Funding in Egypt. He also served as a country director and deputy country director for different INGOs as chief of party or deputy chief of party on a large-scale US aid funded programs in Iraq and Egypt. Throughout Dr. Adawi's career in the MENA region, including positions in Egypt, Iraq, Yemen, Tunisia, Sudan, Syria, Palestine, Jordan, Qatar, and Lebanon, he has worked to strengthen the institutional capacity of civil society organizations and to increase their ability to advocate and coordinate with the government. Dr. Adawi worked in drafting the NGO's law and its bylaws as well. He was deeply involved in the process of drafting the law and in conduction of series of awareness events about the law for many national and international NGOs in Egypt. Before I move the floor to Dr. Issam, let me tell you how the session will go. Dr. Issam will walk us through critical issues related to the new executive bylaws. And while he walks through his talk, please feel free to send us through the chat box your comments or questions. At the end, after Dr. Issam finishes, we will open the floor for Q&A. So we'll just need to raise your hand and we will allow you to address your questions directly to Dr. Issam. Thank you so much, Dr. Issam. The floor is yours.
Thanks, Kareman, for the nice introduction and the nice words about myself. Thank you very much for that. And thanks for all the participants who took from their time just to be with us today about the NGO law and about the bylaw itself. Let me say something that is about the new NGO law that has been issued in August 2019, and it replaced actually one of the worst NGO laws that has been issued on 2017, one of the worst in the world actually, and we are lucky that this law did not take that long. I think take about less than a couple of years, and then they canceled it. The new NGO law, I think many of you, they do have the English version of it, and if not, I can share it with Kareman, and she can share the English version of the law and also the English version of the bylaw itself, so we can share it with all of you. Definitely, it is not that 100% because there is a revision of the bylaw. It's English, but I think the one that we have, it is almost final. If we talk about the law itself, the law, it has 97 articles. The NGO law 149, it is 97 articles in addition to 9 issuance articles. While the bylaw, it includes 188 articles that it explains the law itself. So I'm saying the number just to say that it is not easy to swallow the law, either for the practitioners nor for the administrative authority, the people that they are applying the law. So it's not easy for us and for them to understand it. And I think we will take a while of confusion from our understanding to the articles and also from the people who are applying the law itself. So there will be a confusion among them in how they can do apply the article and understand it and interpret it. As far as I know, the ministry now, they are doing a series of training sessions for their team, not on the central level, because at the central level, most of them, they are really aware and because they participated in a way or another in drafting the law. But when it goes to the directorates and the districts, the issue is a bit difficult and really a bit confusing, and the understanding at the central level of the ministry is not trickled down to include the districts and at the governorate levels. Let me say that when we talk about any NGO law in the world, we do have some important elements or parameters that we need to know about it. While the others, it regulates the work, yes, it is important, but the most important, we are talking about 10 elements. The first element is the establishment. This is number one. How the new NGO law organize the establishment either for the association or for the federations or for the international NGOs or whatever. So establishment is number one. Number two, and it happens only when there is a new law. And mainly it gives a 1 year for it. And so it is number two, which is now very important and crucial to us, is what we call it the adjustment of the status or tawfiq al-awda. Number one is the establishment, which means التأسيس, how we can. And then number three is the dissolution, أو الحل, who is going to take the decision to dissolve institution or stop the work of any NGO law, either national or international. Number four, which is really very important for both national and international NGOs, is the funding. How the law and the bylaw deal with the funding. This is number four. Number five which is very important for the local NGOs about the resource development. تنمية الموارد. What are, how the law and the bylaw give benefits and some things to resource development for the CSOs. And after that is the benefits. What are the benefits for the local NGOs or for the international NGOs that they are working? The third, the one after that is the banned activities, أو الأنشطة المحظورة, because we don't want to deal with anything that is not permitted by the law, and then we are dealing because ignorance with the banned activities. It's something, backfire is not good. And then we are talking about the penalties, العقوبات. After that, another element is the inspection and verification. Who is gonna to see what we are doing and how many actually authority that they are dealing with us and how they are doing the inspection and the verification. And the last one is the administrative authority. Who is gonna to implement the law and apply the law for the NGO. So this is the main 10 issues, among others actually, but this is for any civil society law or NGO law. This is the most important things, and basically we need to know about them very well actually. If we take it one by one, and I'm not going to talk a lot, but I will just touch on the fly for some issues, and I will go in depth in some of the important ones. For the establishment, the bylaw itself, it has about about 8 articles. The law itself is about 8 articles about the establishment, and the bylaw itself is about from Article 14, the bylaw, Article 14, 15, 16, 17. 4 articles in the bylaw, it talks about the establishment. Most importantly is that the establishment of an NGO now by the new law is by notification. So we have to notify, and we are not waiting for the approval. So this is by the Constitution, because the Article 75 in the Constitution, it was very clear that the NGO, foundations, whatever, they can be established only by notification. But now if we go to the notification, when you would like to notify the ministry, okay, then could be easy and it might be difficult, because now we go to the bylaw. You can notify me by two steps, just a letter and the name of the people, and also you can notify me by 20 steps, and both are according to the law. Actually, in the bylaw, it is not that difficult. The issues or the requirements, documents for the establishment, it's not difficult, and I think it's okay. Then we have the Article 14, 15, 16, and 17. For any NGO would like to establish itself, they have to, we have 2 forms of establishment. Either you would like to establish it as an NGO, or what we call it جمعية, or we establish it as a foundation, مؤسسة. What is the difference between both? Both of them, they are doing the same work. There is no difference in conducting the work. With the association, you do have an elected board of directors, and at least 10 people. You have to get together 10 people and apply to establish an association, and you select a board of directors that they have an election every 4 years to change the board of directors. And you are doing your work according to the law. What's about the foundation? The foundation, it comes from founders. And it could be founded by 1 member, 2 members, 3 members, whatever. And instead of board of directors, there is a board of trustees. And the board of trustees, there is no limit for their time, okay? Unless they can change it either from the founders. If they would like to replace one of the board of trustees, though it is by a decision from the founders, but there is no election, nothing. For the association, there is fee, which is about 2,000 maximum, maximum 5,000, and with the bylaw they mention it is 2,000. But for the by foundation, it is 50,000 because they supposed to support the foundation. In Muassasa is mainly funding for funding activities, but while the association they are trying to do resource mobilization, resource development in order to serve their communities. Those are the main 2 forms of the local NGOs. Now, for any foreign NGOs, then there is they can establish an office or they can establish a branch for an international NGO. And for the international NGOs in Egypt, they have to be registered through the Ministry of Foreign Affairs and the Ministry of Social Solidarity as well. So the window to apply for the international NGOs in the Ministry of Foreign Affairs. But they have to be also registered within the Ministry of Social Solidarity because they are the administrative authority. What's new? The 4th element, which is new for this law, about the communities within Egypt. For example, what we call them a Galiyat. For example, the Nigerian community, for the Armenian community, for the British community, whatever. Now they are allowed to open an association, not a foundation. Why association and not a foundation? Because the association, anyone they can get and join them, and then it has to be open for anyone from this nationality to enter the association. But for the foundation, it depends on the founders that they can accept him or her in the board of trustees. So it should be an association. And it depends on actually on the reciprocity actually, because dealing between the countries is the same. If the law in this country allows Egyptians to open an association, then the law here, it allows them. If the law did not or forbid or did not allow any foreign communities in any country to establish an association, so they will not have the right to establish an association in Egypt. So it is mutual cooperation or based on the reciprocity. And this is something about Galiyat, and this one is new, and they have to be 50 members, not only 10. So if one of the communities would like to establish an association, they have to be at least 50 persons from the same nationality, But the law also, it gives for the foreigners who do have legal residency here in Egypt to join any of the local NGOs. For example, if a local NGO in Asyut or in Minya or in Alexandria, wherever, and there are many foreigners who would like to join the association, then they have the right to do it, but with maximum 25%. 25% of the either board of directors or with the either the board of directors or of the General Assembly. So 25% from the association. Any association can be foreigners, with those who do have legal residency in Egypt. This is in general the establishment, and I think now it is easier than before. There is some document that we have to fulfill it. The most not irritating, but the most demanding one is they need to have all the members, the criminal history, which is, we call it the fish with the criminal history, that they have to submit it with the papers that they need to establishment. Before that, it was something only for the Egyptians, but for the foreigners, just a letter from any legal office that they are not on any list of the terrorist list or whatever. So only for the local persons, they need the criminal history, but for the foreigners, just a letter from them or from a legal office that they are having nothing violating the law. This is number one about the establishment, and it is now we can move to the number two, which is the adjustment of the status. The adjustment of the status, it almost always, it came actually after any law or bylaw issued. Then they give you a chance to adjust your status according to the new law. If we talk about the current law, it is issued on 2019, but the bylaw, it's issued in 2020. So after about a year and a half. The bylaw, after the issue of the bylaw, and according to the law, we do have 1 year to do the adjustment of our status. The adjustment of our status, I think literally it is something like the establishment. They need certain documents, which is self-explanatory actually in the bylaw or on the law itself. In the bylaw, there is about 11 articles about how to adjust the status for all the NGOs, either national or international. So adjustment of the status, since the bylaw issued on January 2021, on the 11th of the 2021, then we have a year to adjust our status. If we fail during this year to adjust our status, then the Ministry of Social Solidarity will ask the court to dissolve whoever did not apply for the adjustment of their status. Because the dissolution or to dissolve an entity that is already registered, it cannot be done by the minister or by the administrative authority, but it is by the court. So they will raise the names of the associations, foundations, whatever, that they are failed to submit to adjust their status, and then they will take it off or they will erase it from the database of the Ministry of Social Solidarity. For the time being in Egypt, the registered NGOs and association NGOs, it's all in all about 53 something NGOs. About 3,000 of them, more or less, they are foundations, while the others are associations and unions. So they have to adjust their status. Is it easy for all of those to apply to adjust their status? I think it's not easy for the administrative authority to be able to get all those applications. But whoever is working in the area of civil work, actually, they can see that this is just from my point of view, that about 25 or 30% of those, they are only on papers. They are not now active, or they are not even there, okay? More than 25%. While those who are there but inactive, you can add the same percentage to it, or at least, or even more. So if we talk about 53,000 NGO in law, whoever is active is less than 50% of them that they are active. There are the high flyers that they are really very, very much active, and there are some people that they are struggling to active, and there's some others, they are working mainly in charity or development. So, but I think less than 50% of those, they are really working on the ground. So I'm expecting that about more than 30 to 25, 30% of those associations, they may not adjust their status. So this is the adjustment of the status. We have to do it before 10th of January 2022. We have to do it before the 10th, or at least start the process of the adjustment before this date. It may be extended beyond that if you applied for the adjustment. As far as I know, and the adjustment of the status, they will open very soon a website that the organizations, the international NGOs, the foundations, they can apply for the adjustment through the website. Some of the NGOs, they are really simple and they cannot deal with they are serving local communities like the CDAs, community development associations in many of the villages. They may not have the technology that they can apply for that. So it is open also for them to apply it in papers. So both are open. The website, I think they promised that they will open it this week, but I think it may take another week to be opened. And then for those who would like to apply, they can go and they can apply and adjust. And there was a meeting actually at the Ministry of Social Solidarity last Thursday where they experienced, where they show the website and how it works, and how the association, every association will have a number that it is not only the registration number, but their number, like the ID of the association, it is from 13 digits. So it is 13 digits that it constitutes the ID of the association. So it would be different from, it would be only unique for any organization, association, foundation. It will have its unique number. So this is in addition of its registration number, because it could be number 1, number 2, number 3. Some of them, they don't want to lose the number because it gives history for them, but they will have another ID for any organization from 13 digits. This is for the adjustment of the status. And for the international NGOs, in Egypt, so far, currently there is 59 international NGOs, they are working in Egypt. Not all of them, they are working in the area of social or economic development. Some of them, they are not working on this, about 25 or 30 only international NGOs, they are working on the area of development. So they will adjust their status, and it's something good. For example, if you did the adjustment of the status, actually, for example, on September, okay, and your license would be finished in October. So it doesn't make any sense just you do the adjustment of the status, and then after a month or 2 or 3 or a year to do another relicensing. So they took a decision in the Ministry of Social Solidarity that they will consider the adjustment of the status as a license. They will extend it for 1 year, 2 years, 3 years, whatever. As far as I know, it will be 3 years, but it could be less. But as far as I know, so any international NGO, they are working in Egypt, okay, they will adjust their status free of charge, and also the adjustment of the status is free of charge actually for any entity actually, for any entity. So they will get 3 years, 2 years for the international NGOs, free license till the next extending their license. This is what I have been hearing, and I think this is what will happen for sure, at least 1 year, but I think it will be about 3 years. After that, when they apply for renewal the license, they have to pay 50,000 Egyptian pounds for every renewal. And this renewal, it will increase 5% for every year. So I think 50,000 now, I know it's a big of money, but for the international NGOs, that's fine, I guess. Okay. So this is for the 59 international NGOs they are working in Egypt. There is something which is really confusing, and it is very new for the adjustment of status for this law, which is they call any entity that they are performing or working in the area of civil work, العمل الأهلي, they have to adjust their status according to the law. And this is really very confusing. I can give you an example. For example, if there is a company that they are giving services and they are dealing with international NGOs, dealing with local NGOs, dealing with foundations, dealing with whatever in the area of development, in the area of training, in the area of staff development, in the area of research, whatever, but it's a company. This is considered, if they consider this عمل أهلي or work of NGOs, then they have to get and adjust their status. But I was very clear while I'm asking my colleagues at the ministry that العمل الأهلي or the civil work is non-profit. It is non-profit, and it is really, they identify it as non-profit. If it is a company, so it is not عمل أهلي, it is a service provider, so they don't have to adjust their status. So this is something that, because many of those actually firms that they are supporting and working in the عمل أهلي, and they are companies, and they are for profit, and they are paying the tax, they are paying their part of the insurance, and they are working according to the law of investment. So it is not عمل أهلي, it is actually service providers. And let me give you a background history about actually this article and why they put it. Okay. Actually, there were some firms that they are doing عمل أهلي. They are taking funds, they are getting grants from foreign funding, etc. And they were not registered as an NGO. They were registered as, for example, a lawyer firm or a clinic or a center or whatever, but they used to compete and they used to work and doing the work of the NGOs. Those they were 40, they identified at that time about 44 firms that they are doing the work of the NGOs, and they are not registered and not under any supervision from any administrative authority. So this actually article, it has been put into the law in order for such entities. Of course, it is not, secret that most of them, they are working in the area that it is not that preferred. They are used to work on the area of human rights, actually, and this is why they were a little bit labeled that those 44 entities, they are sort of irritating some of the people or some of the firms, government during that time. So this actually article, it has been put for that reason, but for those service providers, there is no problem. They are doing it for profit, so there is no problem for that. Also, for example, if there is a church or if there is a mosque, and those people that within the mosque or within the church, and they are supporting their communities, whatever, and they are not registered with the mosque, but they are doing like amal da'wi. They are advocating for principles, for religious principles, and at the same time they are serving their community. Also, they are not obliged to adjust their status according to the law, since they are belonging to one of the firms or one of the institutions, either mosque or either the church or whatever. So also those, they may not be allowed to do that. But in general, this is what the law is doing. Okay, this is what the law is saying. But application of the law and the people who apply the law, they may see otherwise. Okay, and I hope you got what I mean. Okay. This is number 2 about the adjustment of the status. Mainly, all of us, we have to do it, and at the same time, before 10th of January 2022. Otherwise, it will be dissolved. Now we came to the third, which I will touch it quickly, the dissolution. This law actually, it gives a benefit that no one can dissolve a registered organization or a registered entity by a decision, unless it is by the court. So the court only that they can dissolve either the firm or the board of directors or the board of trustees, whatever. So if the Ministry of Social Solidarity or the administrative authority see that there is one of the NGO, they are breaking the law or they are violating the law, so they cannot dissolve it. They can ask the court, they can give the reasons, and the court, they can take the decision to dissolve it. But the Ministry of Social Solidarity, the administrative authority, they can stop or seize the work for maximum 1 year. So I can tell you, they can tell us that you are violating the law 1, 2, 3, 4, 5. You are doing this, and based on that, I'm stopping you from work, okay, for 1 year. The association or the NGO, they can object that, and they can apply for the court that it is not their reasons, is baseless, whatever, and then the court will judge about them. But not more than 1 year. After 1 year, then they are not allowed to stop it. Okay, so the dissolution came, and this is something also, it came on the Constitution. And I think the Article 225 of the Constitution, that dissolution of any NGO, it has to come from the court. So this is the dissolution. But if the foundation or the NGO, they would like to dissolve themselves, this is الحل الاختياري. For an NGO, we are not became active. We are having many problems. We cannot stay, we cannot work, we have no funding, so they can take the decision to dissolve themselves, okay? And then with the foundations, the application came from the founders, and with the association, the board of directors, they have to ask the General Assembly to meet and take the decision, not the board of directors, but the General Assembly. This is one of the decisions that they have to be by the General Assembly, not the board of directors. But with the foundation, it is not the board of trustees, but the founders. المؤسسين, they can take the decision to dissolve it voluntarily. So ده الحل الاختياري. So either by the court, or if you would like, of the NGO would like to dissolve itself. There are, I think, 3 articles. Article 13, 74, 107 on the bylaw. It talks about the dissolution, and on the law, it is 3 articles also. It is 45, 46, 47. They are talking about the dissolution and the steps and where the money it goes after that, where the committees is, etc., and who will take the decision and who is going to seeing a liquefier and everything. It goes after that. Okay, now we came to one of the most important elements, which is the funding, actually. Which is the funding. This is the first law that it gives flexibility for the funding. Law 70, it was really very sarcastic, and actually it was really very funny about when they allowed the NGOs to have funding, either foreign internal or external funding. They were very funny, actually. They put very funny articles on this law. And the 84 that we used to work with us, it was only by permission. So if you would like to get an external funding or internal funding, you have to get an approval. Not, and the approval, it may take a day and it may take 10 years. So, and mainly the approvals, it goes and we go ask, and then they said we did not get any approval, because the approval, it came from actually, is not from yes, the administrative authority, the window for the approvals, but the approvals, it came from the security, actually, from 2 firms of the security. Now it became 3 firms of the security that they gave their opinion. What's new in this actually is 2 areas. If there is foreign funding, the foreign funding, either it came from a foreign NGO from outside Egypt or from an international NGO inside Egypt. If it is coming from outside Egypt, okay, the local NGO, they say they can apply for one of the forms or one of the formats that they are related to the bylaw, that we are receiving this amount of funding, and they can fill the form and apply to get the approval for the foreign funding. In case the international NGO that they are giving the funding is registered in Egypt, there is no approval, there is no need for approval. It's only notification. Let me give an example. For example, if the international NGO, for example, Save the Children, Plan International, whatever, they are already registered in Egypt, and they would like to give a grant for another registered local NGO, so there is no approval here. It's only notification, so they can notify. Since both of them, they are registered. What if it is not registered? So they apply, and from the day of application, you can wait for 60 working days. If there is no reply within those 60 working days, which is about 3 months, then it is approval. So non-responses is approval. Before that, why I'm saying it is funny, because the previous law, they said, if we did not get back to you, it is refusal. So if you did not meet, if you did not look to my application, if whatever, many things, so it is a refusal. And it was clear on the previous law that if we did not meet to look at your application, then it is refusal. So if you did not meet, why I'm got punished because you did not have the time to meet and look to my application. So why you are refusing it? So, but with this law, it is 60 working days. But there is something here which is really a little bit tricky. Who are the international NGOs? They are registered, only the ones that they are registered with the Ministry of Social Solidarity. What's about the UN agencies? They are not registered within the Ministry of Social Solidarity. So the UN agency, we consider a foreign funding. What's about the embassies? The embassies, they are foreign funding. So they have to wait 60 working days. So for example, if the UNICEF, they are in street 15, for example, in Maadi, and Save the Children, it is the neighbor in, for example, on street 14. And if both of them would like to support one of the local NGOs, UNICEF, they are an international, they are an UN agency working in Egypt, legally working in Egypt, and they are registered in Egypt at the UN agencies. But since they are not registered within the Ministry of Social Solidarity, so it is foreign funding, so it applies the 60 days. The 60 days. What's about the embassies? The same. What's about the organizations? International NGO, they have a bilateral agreement with the Egyptian government. For example, like CARE International, like Ford Foundation, like CRS. Those are international NGOs, but their agreement is a bilateral agreement between Egypt and between the government of Egypt, the president of Egypt, and the foundation. So they are not registered on the Ministry of Social Solidarity. So the 60 days applies for them. When I raised this question actually with the minister and with the colleagues at the ministry, they said they know that this is a little bit situation that they would like to deal with it, but they would say if UNICEF, for example, supported this local NGO, okay, and they got the approval, so this approval it would goes forever. So they are not going to apply for another approval. So if they approve from the first stage, but this is what they promised for, though they will apply it or not, this is something I cannot say it 100%. But they told me and they said that if they got this approval once, so we will not, we will give the approval immediately. But they need an approval. This is for the foreign funding. For the ministers, for the embassies, yes, it is foreign funding. For any other things that consider them foreign funding for the 60 days. The good thing is the law that obliged them to issue the letter of approval within 5 days after those 60 days. So of the 60 days, it ends on April 1st, then they have to send the letter of approval on with the same week. So it's only 5 working days. So they have to send. The problem is not here. The problem is within the bank, because the money, it comes to the bank, and the bank, they did not actually release the money until they get a letter from the administrative authority. Even if there is a notification, the bank, they don't know about NGOs, they have no interest for it, okay? You are an NGO, you got the money will be freezed until I get a letter from the mosque. Within mosque, the colleague there, they told me if it is a notification, if they notify us on the same day or the next day, we will give them a letter to the bank in order to release the money. This is within on the central level, but what's about on the governorate level, on the district level, we will see the practice, how it will go. This is actually for the funding. I will go quickly for the resource development. I will say some of the benefits that the only thing that is really actually became new one is for any NGO, they have the right to establish companies. Now, from the money that they are getting as a revenue. Of course, it is not for profit, but the company is for profit. Definitely why they are establishing the company is for profit, but the profit, it goes back to the NGO. So to be spent within the NGO itself. So they allow them to establish companies, and this is what is new in this law actually, while the other, they are already either establishing service and productive projects. This is something that goes for ages, okay? Many of them, they are doing exhibitions, they are producing materials, they are selling honey, they are doing many production projects. This is, it goes. Some of them, actually, they are doing charitable fairs, exhibitions, whatever. This is something new, all, but they are holding exhibition, they are doing whatever. But the only thing that is actually new is they are now allowed to establish companies. But the board of directors of the company, it is totally different than the board of directors of the association or of the foundation. So they have to establish the company with a new board of directors. They run the company as a profit organization. Definitely the board of directors of the company, they report to the board of directors of the association, but they are having free hands. And because now the board of directors or the board of trustees, they are not allowed to take any fee or any money or any expenses from the money of the organization, and it is really crystal clear within this law actually. So if I'm, for example, I'm a board of director of one or two of the foundations, I'm not allowed to take a penny out of them, of the money, okay? Some of them, they said your expenses, but some of them, they said no money whatsoever to get it as a board of director. But for the investment companies, okay, it's belonging to the investment law. But the money, the profit, it goes to the organization. This is something that is new for the resource development, and every association, they have only, for example, if they would like to do an exhibition, a fair or whatever, they are allowed only for one event a year, unless they get an exception from the minister. So they have only one event per year for fundraising. We can go now to the something that we what we call it. I'm going to finish in a few minutes. Band activities. The band activities actually, it is really very self-explanatory. Okay, you can read it either in the law or on the bylaw. But within the band activities, there is actually a bump. There is something that is really number D on Article 15 on the law. That what we are saying for the band activities, performing activities that will impair public order or morals or national unity or security. This is really very tough and very difficult because they did not even identify what is the public order, what is the public morals, what is the national unity, what is the national security. Okay, so they leave it and it depends on whoever would like to interpret it. Maybe if I'm driving my car in the dark, they may call now you are actually doing an activity and you are impairing the national security. They may say that, okay? Once there is no definitions for that, so it opens the door for different interpretation and for personal judgment for what those issues. We were fighting to remove this article, all of us, or at least identify what is the public order, what is the public morals, what is the national unity, what is the national security, ايه هي الوحدة الوطنية, ايه هي الأخلاقيات, ايه هي الأشياء دي, and it was, we did not get clear answer. But with the other issues, that's fine. You can read it, it is self-explanatory, but I would like to only talk about this. For the penalties, we are happy that within this law, there is no actually any penalty that it goes to jail. On the contrary of the previous law, that if you forget to send a letter to the administrative authority that they are moving from flat number 5 to flat number 7, then you would be put in jail because you forget to send this letter. But with this, it's only fines. It is only fines, it is only financial fines, and which is, it might be higher, but at least there is no jail, there is no any other penalty for that. I will stop at that, and then I will open the floor for some discussions. I'm sorry I may take a bit longer than it is anticipated, but I hope I covered some of the things that it might be useful for some of you.
Thank you so much, dear Dr. Issam. That was a very insightful dive into the executive bylaws, really helpful. Thank you for that. Yani, as you mentioned, we are expecting a phase of confusion for a while. That's normal, but we can sense some sort of development relative to the proposed law 70. We can see, as you said, that the jail sanctions have been replaced with less restrictive admin penalties. And the most important thing, as you mentioned, non-reply means approval, not automatic rejection. So we can, to some extent, see the impact of engaging relevant stakeholders in the drafting process. So thank you for that. Before we move on to the audience question, let me raise an issue that I would like to hear your thoughts about. It's related to the cross-border giving. Some of the civil society actors expressed their concerns about, for example, if an Egyptian NGOs want to give a humanitarian aid to Lebanon or Sudan or whatever from our neighbors when they are in crisis. They said that there is some sort of ambiguity when it comes to these things. So does the new law address this issue, or is it still ambiguous?
A little bit ambiguous. But for example, if there is an NGO here in Egypt and would like to open a branch outside, they are allowed to do so. And then can send things from here to the other, to their branch outside. And if they would like to send something related, they have to get an approval from the administrative authority in order to send commodities or funding or grants or whatever to outside. They have to get an approval from the administrative authority.
That's great.
Something also which is really new for this law actually, that we call it the initiatives. If there is some 5 or 6 or 10 persons who would like to do an initiative and they would like to do something for their community, and at the same time they don't want to do it either through one of the NGOs or they don't want to establish a firm to do so. So this is the new law. They open that you can apply for the initiative. They can give you a license for 1 year, and you are allowed to do fundraising, and you can do your initiative, and then by the 1 year, just finish. If you would like to extend, you can ask for another extension. So the initiatives now is really open. This is why they put another sector, or they put a fasl within the law about volunteerism, about volunteering.
Okay, that's great. Thank you. The other issue is related to the CSR, or the corporate philanthropy. Is it true that now companies cannot operate their philanthropic activities directly with the communities if they don't, through their CSR chapters, if they don't have the registered foundation? Do they have to go through a registered NGO to perform those philanthropic activities?
Okay, with the CSR, either they have to establish something within a foundation, within their organization. For example, if the CIP, for example, for the phone, whatever, they do have their foundations. And so they can do that through their foundations. If not the CSR, they can do it through one of the registered NGOs.
This is great. Now we will take some questions from the audience. We have a question from Mireille Nassim, the CEO of Takato Foundation. Mireille, please feel free to unmute yourself and ask the question.
Hello, Dr. Issam. How are you? Thank you, Kareman. I want just a clarification. The non-reply means an approval. Is there anything that's supporting documents for this non-reply? Because actually, if you don't have any written approval from the ministry, what if there is an objection note that was sent to the NGO but didn't reach the NGO? Do we proceed right away automatically? Is it safe?
No, I think if for the non-reply, okay, they should actually, after the 60 working days, they should immediately begin to implement that. Here is two problems actually. The first problem is that the bank will not release the money unless he gets a letter from MOS. And the law, they oblige the administrative authority to send the letter within 5 working days after the 60 working days passed. But if there is a rejection, for example, if there is a refusal within the 60 days, then they have to send the reasons. Before that, they can send a letter and they are saying that this is not approved, period. But now, with the law, they have to send why they refuse the grant or why they refuse this project or whatever. And since this law, the NGO law, did not say something that you can go to the court and you can do an appeal for the rejection or for the refusal. But this is already secured by the law in general. So if you got disapproval or refusal, okay, with reasons, then you can write an appeal for the Minister of Social Solidarity. If not, you can go to the court against the Minister of Social Solidarity once you do have the reasons, and you can, then the court, they can say something about it.
Thank you, Dr. Issam. And thank you, Mireille, for the question. We have a hand raised, Martin Sawiris. You can unmute yourself and address your question to Dr. Issam.
Hello, Dr. Issam. Thank you so much first, and thank you, Kareman. I have a question, but before that question, I think, of course, I'm not sure. Of course, you know more than me, but I think that the law about the previous question, that the law said that we can go as at the organization, we can go to the local management after 60 working days to the local management and get the approval from the local management directly. We don't have to get the approval from the ministry. Of course, you know more than me, but I think this was mentioned in the law. So this is about the previous question. About my question, I want to ask about details about funding. So if we are going to receive money from Egyptian entity or person more than 10,000, of course, the entity should put the money directly into the organization bank. So my question here: which bank account, which bank sub account that we receive the donation? Can we, as an entity, as an organization, receive the donation in the main sub account, الحساب التشغيلي للجمعية, or we have to dedicate a special sub account for this issue?
Okay, let me clarify the first point, Martin. You mean by the local administration and the direct rate of the social solidarity on the governorate level or in the district level? Yes, but for example, if you receive a grant or a money, the money, it can come to your bank account. If it is foreign funding, it can come to your bank account. According to the law, you have to send the letter to the directorate, to whoever within the Ministry of the Social Solidarity, the NGO are related to, okay? Within 30 days, you have to tell them that I have received this amount of money, for example, since 1 week, and this amount of money we are going to implement this project with this, and this is the project, this is the things according to the format that you have to fill. Okay. After they receive this, you wait for 60 working days. Okay. If they did not hear anything, then they have to give you a letter to the bank that they release the fund. Okay. So you do have an approval by the 60 days. It's already approved by law. So you have an approval. What you will take from them is a letter to the bank to release the fund. Okay. And if there is a coordination between the bank and the bank, they know the NGO law, they can do it themselves without any letter. But you know, they are belonging to another law. But after the 60 days, you have the approval. You are not going to ask for approval because you already got it by law. But what you are looking for is a letter to release the fund from the bank. I hope it's clear. And you can go to any directorate on the level on the governor, because you are not allowed, you know, only the central NGOs, they took the letters from the ministry, but the others, they took the letters from on the governorate or district levels.
Thank you so much, Dr. Issam, and thank you, Martin. We have Ahmed Helmi. Could you please unmute yourself? Ahmed Helmi, you have a question?
Yeah, I'm here. Thank you so much, Kareman. Thank you, Dr. Issam. I have one question related to the 60 days rule. What if the administration authority sent a rejection letter before the 60 days, and let's say we have responded? Should we restart counting the 60 days? So this is one question, because you know all these tricks. I think it's, if there's any way to make sure that this is not, it's guaranteed that will not happen, or it might happen.
Okay.
Yeah, those are two questions. So if you wish, I can say the other two questions. Second one is related to the tax card. Is it necessary to have a tax card for international NGOs? And the third question is regarding to establishing a branch of international NGOs. Does same rules you have mentioned apply here, or there is something else we need to consider? Thank you.
For your first question, if you get a rejection or disapproval, so they will not count another 60 days because you will go to another path actually. Okay, you got the refusal, okay, with reasons why they are actually refusing your grant, and then you will write an appeal for them or respond to their reasons of refusal, okay, and to write an appeal. If they refuse your appeal, then you can go to the court, okay, and then this is another path. They are not gonna to count another 60 days. It is not another grant that comes for you. So this is another way that you are going to. Either you appeal or you go to the court and or negotiate with them why they refused your grant. The second one, the tax, there is no tax number for the international NGOs or whatever. There is no tax card for that. But if you are buying, you are not exempted from the tax. But for the local NGO, they are exempted. For the international NGOs, if there is a service provider or whatever, so you are belonging to the tax law that you are deducted the tax from the origin if they will have, you give them the money. Some of the service providers, they ask you to get the tax from them actually. And the third question about the, I forgot what the third question actually, Kareman?
I guess they were just two questions.
No, I think there are three questions.
I'm here now, sorry. I was always face a problem of unmuting myself. Third question was establishing a branch of international NGO. Yeah.
Okay, a branch for an international NGO, it's now open, and you can, any international NGO, they can apply for the Ministry of Foreign Affairs first, okay, with certain regulations, okay, and then they can ask for the international NGO. It is very clear and below that what are the requirements for them, and they wait actually till they get the approval, and after they get the approval from the Ministry of Foreign Affairs, then they can do the registration, could be on the same day with the Ministry of Social Solidarity. As I mentioned earlier, there is 59 international NGO, they are working now in Egypt, and they can open any branch.
Thank you so much, Dr. Issam, and thank you, Ahmed. We have a very interesting question from Mai Saeed. Mai, if you can unmute yourself. Mai? Okay, okay, I will address her question. Maybe we lost her. She's asking if we could please talk a little bit about whether we can carry outside research like community profile, situation analysis, baseline and endline evaluation in targeted location. She says that there is always this uncertainty about the topic of collecting data and beneficiaries of development projects, keeping in mind that a consent is acquired and before ahead and all this stuff. So does the new law address these issues?
Oh, definitely. They addressed this issue, and they said, if there is a research, you have to get the approval from CAPNAS. But if we are all working in the communities, and we would like to assess the needs, and we would like to know what the needs of our communities, what the met, what the unmet needs, etc. So they consider this is a needs assessment, it is not a research. And if you are implementing a project and would like to evaluate it, and if you would like to do an impact evaluation, you have to go and ask the people about the benefit that they got it from the project, etc. You can make a questionnaire, you can make something else, something like that. So it is not a research. So if you are evaluating a project, or you are as an organization, you are doing a sort of needs assessment, okay? So they will not consider this as research or a data that you are getting out of it. But if you are doing a research for a specific topic, okay, and you go and you get a sampling and you have a questionnaire and you have something like that, and the analysis tools, etc., etc., this is a type of research that you need to get the approval of CAPMAS to do this research. But for the needs assessment, for the evaluation, for whatever, already it's okay. And even for, especially for the evaluation, because when you apply for the project or funding or whatever, you say there is a final evaluation, midterm evaluation for the benefits, for whatever. So it is already approved within the project itself that you are doing needs assessment and you are doing an evaluation. So within the project, we are mostly saying that we will do the needs assessment and do midterm evaluation, we'll do final evaluation by this way, qualitative and quantitative, etc. This is not a research. This is something that it is considered project activities or interventions. But if it is a research for a certain topic, assumptions, whatever, then you have to get the approval of CAPMAS.
Thank you so much, Dr. Issam. We have a question from Hagar Gihad. Hagar, if you can unmute yourself. Okay, let me address the question to you myself.
Yes.
Hagar, okay, cool.
Hi, I'm sorry, there was a problem to unmute.
No problem.
Actually, I have a couple of questions. The first one is that the adjustment for the NGOs, will it hinder their work? Just if I have some NGOs and they got grants from our company or our incorporation, and they are now seeking the approval from the Ministry of Social Solidarity, and they are adjusting their status. Would this hinder the applying for the approval?
No.
This is the first question.
Two different.
So this can go parallel, okay?
Yeah, you can go parallel. No problem whatsoever. Oh. Even after the bylaw, it's the 60 days rule is applied.
Okay, the other one is that you've mentioned that the UN agencies needs approval, not notification. What's the status of the USAID? Is it counted or dealt with as the UN agencies?
Approval.
Approval.
Okay.
Yes. Okay, thank you so much.
Thank you. We have another question from Surayan. Okay. Ghada Surayan.
Hello.
Hi. Yes, Ghada.
Hi. Hi, Kareman. Hi, Dr. Issam. Actually, I had a question. Our registration expired September 2020, and we wanted to apply for both a new registration and adjusting our situation together, or we have to adjust first, then apply for the new registration?
If you do the adjustment, it goes for both. If you did the adjustment of the status, start the adjustment of the status, they will give you...
It goes for both.
Yes, yes. So only one of them, Yeah, only one of them. So you can do the adjustment of the status.
Oh, okay.
Thank you. It will cover the license.
Thank you so much, Dr. Issam, and thank you to Ghada as well for her question. We have a question from Abir al-Shafei.
Hello.
Abir. Hi.
Hi, thank you very much for all of this great effort. This is really very useful. I actually have 3 quick questions. One of them is related to البيانات الأساسية حول المنظمة الأم. Like what is the information that we need to upload or to send about our mother company or our HQ office as a foreign NGO. As I understand from my readings, they need three points. One of them is a legal license whereby this organization is operating in its country. That's fine. The other one is official copy of the general system, like لائحة النظام الأساسي. There's no such thing as النظام الأساسي in the HQ office. They have different guides, they have different systems and policies.
We do have manuals, financial manual, HR manual, whatever those can consider be the bylaw.
The financial manual?
The financial manual, the HR manual, whatever. This the
HR manual. Okay,
but
and
the point here is you need to authenticate it in the Egyptian embassy on the country of origin.
Which is problematic because we've recently had a change of our regional director and we had to do a power of attorney and we had to wait for that to be signed and authenticated, and actually took more than 3 months. So that's something to consider, and we will have to proceed with it and see how much time it's going to take us, but because this is outside of our control.
Already registered in Egypt.
We are.
I'm sure that all those documents, they already there in your files.
Yeah.
Most of those documents I already
since 2005 though, like more than 15 years ago. So, but anyway.
No, they need an update definitely.
I'm sure. And then the last part about this point is the information about the board members. So what kind of data do we need to provide? Yani resumes only?
Yes, and a letter from the legal firm that they are not on the terrorist list or whatever. This is something, a letter that they are not having
in their countries, because these are people in the US.
From their country, yeah. A letter from their legal. I'm sure that your international NGO, they do have legal firm.
They have a legal department.
From the legal firm, authenticated from the Egyptian.
Okay, and the next question is related to our اللائحة الداخلية organization here in Egypt. So again, we don't have something that includes all of the information that I read in the law. Like we don't do this, we don't do that, because this goes without saying that we are not involved in anything that is illegal. We are not in activities that are against the system or whatever. This goes without saying. We don't really have a specific internal list that has all of these items. Do we need to invent one?
Okay, let me tell you. We need to differentiate between local NGO and international. Okay.
And what?
Local NGO, there is a model or there is an namuzaj for the bylaw that they can write something similar to it. Okay, so it is for the local NGOs. But for the international NGOs, whatever their bylaw it says, some of them they don't have a bylaw. ما عندهمش لوائح، ما عندهمش لائحة تنفيذية, but they do have manuals.
Yes, we do.
Okay, those manuals in Arabic and in English, it can cover you can consider this is our bylaw. This is how we are dealing with the team. This is how we are dealing on the finance. This is how we are dealing with the purchases. This is how we are dealing in the administration. This is manuals, okay? So this consider as a bylaw.
Thank you very much.
But you have to say it actually in both languages. And I'm sure that you have submitted something like that to the ministry.
Thank you so much. Thank you, Dr. Issam. Thank you, Abir. We have a question from Khalid Swaylam. Khalid, please feel free to unmute yourself.
Hello. Hi. Hi.
Hi.
Do you hear me? Yeah. I mean, when I read the bylaws, just to get to understand that makes a distinction between two things, between the NGOs that do not have a bilateral agreement with the government. So for the first category, I mean,
Kareman, do I hear?
I cannot.
Something from my side.
I think it's from Khalid's side. I cannot hear you clearly. It's glitching.
That there will be no need for the status, the so-called status. Do you share the same understanding that I have for this early now, or do you hear
now,
me?
Khalid,
Hi.
now we can hear
Hello?
you. Hi,
Hello?
I'm sorry.
Hello? Hello?
The voice. Hi, Khalid, the voice was glitching. So can you please repeat your question if possible?
Or if he can write it.
Or if you can write it. I guess we might have lost Khalid. Khalid, are you there?
What I understand.
Hi, do you hear me better now? Hello?
Yes,
There is a
Khalid.
network.
I think we can hear you better now. If you can ask your question or type it. And unfortunately, I guess
Hello?
there's something wrong with your.
Hello? Do you hear me?
Now we can hear you.
I'm so sorry. It looks like there is something wrong with the network.
No worries, we can hear you now.
Yeah, what I was saying is that per my readings to the bylaws makes a sort of distinction between two categories of NGOs. The NGOs that have a bilateral agreement with the government, and those NGOs who do not have a bilateral agreement with the government. For the first category, I mean, to my understanding, they are not requested to have the so-called status adjustment. So the question here is that, do you share the same understanding with me, Dr. Issam, or you have another view?
Okay, let me tell you, and I will give it by examples actually, okay, to make it a bit clear. For those organizations that they are working with bilateral agreements, there is no end for their agreement. It is a bilateral agreement between the organization and the government of Egypt. So it's forever, okay? They are not registered within the Ministry of Social Solidarity. If they would like to change this bilateral agreement into an international NGO agreement and do adjustment of their status, they can. But then they will get a license for 3 years, for 5 years, for 2 years, whatever, and they have to renew it. But if they continue as a bilateral agreement, then they will be dealt as a foreign NGO law, as if they are dealing from outside. So because the bilateral agreement is between the government and the firm. For example, Ford Foundation, okay? This is for the CRS, the CARE International. Those are bilateral agreements. In fact, I don't like this situation. They are international NGO, they are legally working with Egypt. They should be considered as an international NGO, but they are working legally. The type of registration, it doesn't differ. We are working in the same country, we are under the law, we are working according to the law, we are doing so, they should be treated equally actually. And even with the UN agency, they should be considered as an like the registered NGOs. But unfortunately, this is what they said. This is what they mentioned in the law, that they are different. Kareman. Okay.
Hello, Dr. Issam.
أيوة خالد.
Thank you so much for your, thorough response. If I may have another question, it's a related one with the answer that your good self just said right now. I mean, if I'm as an NGO that have a bilateral agreement with the government, I'm exempted from the status adjustment. The bylaws itself, it speaks for several things, just like namely the financial audited financial statements and the volunteer. If you have to hire a volunteer, there should be a sort of a certain contract with this volunteer in the templates made by Ministry of Social Solidarity, and your bank accounts should be supervised by the central unit. So the question here is that, having these articles, am I requested as an NGO that have a bilateral agreement to honor these obligations with regards to the volunteer and the certified financial statements and the supervised bank accounts, etc., etc.?
Okay.
Or I would have another, status. This is what I wanted to share with you, with your good self.
Okay. The bilateral agreement, it depends on its articles itself on the bilateral agreement, okay? It has nothing to do with this NGO law. With the bilateral agreement, they do have certain clauses within the agreement, and both parties, they respect it, okay? But if this organization that they do have a bilateral agreement, they are dealing with a local NGO, the law, it applies for the local NGO, okay? And they are dealing with the international, those with the bilateral agreement as a foreign funding. So they are not requested to see their bank account. They are not requested to see whatever, because there is a bilateral agreement between the country and the firm. Whatever the agreement says, it goes.
This is brilliant. Thank you so much, Dr. Issam, as always, very generous with your time and your effort. We really appreciate this. Thank you so much, and we're so grateful.
Okay, thank you.
Thank you so much.
That was useful for.
That was very useful, I assure you. Thank you so much, and thank you so much for the audience for sticking by till now. We really appreciate your presence. And please, before, just after the session, check our webinar series to learn more about our coming webinars. Thank you so much. Thank you, Dr. Issam, and enjoy the rest of your evening. Thank you.
Okay.
Bye-bye.
Bye.